Valley Ranch versus Latoya Leitner.
Before today's hearing even begins, this case already raises one of the biggest questions in landlord-tenant court. What happens when a tenant believes they've paid, but that payment suddenly disappears? At first glance, it might sound like a simple bookkeeping issue. In reality, a reversed payment can completely change the legal status of an eviction case. What was once considered resolved can instantly become active again, putting someone's housing at risk. Watch closely, because Judge Simpson has to separate sympathy from legal procedure, and that's never an easy balance. You'll hear arguments about bank reversals, payment obligations, and eviction timelines that affect thousands of renters every year. But that's only the beginning. As this docket continues, we'll also see payment plans, emergency hardships, consent judgments, defaults, and judges attempting to balance compassion with enforcing the law. Pay attention to how every party presents their story, because even small details can influence what happens next. By the end of today's session, you'll likely have your own opinion about where fairness ends and legal responsibility begins.
Lucy Manson on behalf of the plaintiff.
Ms. Leitner?
Yes, sir.
All right. I granted a judgment for possession. Is this your motion?
Your Honor, this is plaintiff's motion.
Plaintiff's motion. All right. Go ahead with your claim.
Your Honor, we are asking for reissuance of the order of eviction. The order of eviction was previously entered on May 28th. However, Ms. Leitner had ended up paying the amount, so we had not proceeded with the writ. However, one of the payments that she made to satisfy the judgment has now been reversed. So in light of that, the judgment is now not satisfied, and we would ask for reissuance of the writ. And at this time, no other payments have been made. There's a balance of $8,596.46.
Ms. Leitner, what do you have to say to that?
So, as far as the payment being reversed, I didn't even know in June that it had been reversed until I went to pay my July rent. I'm currently not even in the state. I'm working out of state. I have been since I got out of recovery from my surgery in June, and I don't even have access to pay online anymore. They want a cashier's check in person, but I've been working 7 days straight. I have not been able to get back to the state.
Okay. And you're saying that you have this amount?
Yes, and I don't have any family in Michigan that I trust enough to go to my banking institutions.
Your Honor, we would object. I mean, it's almost $9,000.
No, I hear you. I'm just saying, but I'm trying to figure out.
And the reverse payment, I contacted my bank, and I'm still waiting to hear back on why it was reversed. It hasn't shown back up in my bank account. Because I didn't issue a fraud alert.
Okay. Well, ma'am, what I'm going to do this time is I'm going to grant their motion for the reissuance of the writ of restitution. I'm not sure exactly where you are, but what you'll have to do if you want to resolve this is somehow or another you need to get back into the state and certainly pay the amount of whatever that reversal is once you sort that out. But at this juncture, I am going to grant their motion, reissue the writ, and I've signed that. I signed both the order and the writ today.
This ruling may sound harsh, but legally it follows a straightforward principle. The original eviction process had been paused because the landlord believed the judgment had been satisfied through payment. Once that payment was reversed, the court essentially viewed the debt as unpaid again. Judge Simpson isn't accusing the tenant of fraud or bad faith here. Instead, he's recognizing that, from the court's perspective, the landlord no longer has the money that satisfied the judgment. That's why the writ is reissued. Notice that the judge also gives practical advice rather than simply ending the conversation. He tells Ms. Leitner to resolve the banking issue and return to Michigan as quickly as possible. That shows the court isn't closing every door. It is enforcing procedure while leaving room for the tenant to fix the situation. What do you think? Should a tenant receive additional protection when a payment reversal appears to be caused by banking complications instead of intentional misconduct?
Right.
Thank
Okay, thank you.
Do I know how long I have?
Well, there's a 72-hour, from once it's posted, there's 72-hour wait. But I'd say the best I can tell you is you're operating on borrowed time.
I understand that, Your Honor.
Okay, thank
All right,
you.
thank you.
Arbor Woods versus Leticia Johnson. And go ahead, I'm sorry.
Sorry, Your Honor. Casey Madsen for the plaintiff.
And your sidekick, Adrian. Hello, folks. State your name, please.
I'm Leticia Johnson.
Adrian Johnson.
All right. Okay, where are we on this case?
Your Honor, at this time, all of the repairs have been completed. We do have a proposed agreement for Johnson's. If I was able to go into a breakout room with them and discuss, we weren't able to get a hold of them before court today.
Okay, the problem's going to be that they are here.
Or if
and
I
you
could
are
give them
there.
a phone call.
Yeah.
Pardon? You want to give them a phone call? Do you have their number?
I have
So-
a number. I don't know if that's the number that the phone that they may have on them. It ends in
I have. I'm about to say I have.
What's the last four digits?
of the phone number I have. It's 6076. Sorry, Your Honor.
That's the one that you have?
Yep.
Okay, I'll pass the matter, and as soon as she's done with her cases, she'll give you a call.
Okay.
And you can use the rooms, the vestibule rooms out there. Okay?
Thank you.
Thank you.
Your Honor.
Arbor Woods versus Brandon Wilson. And Kimberly Slayton. Wilson, Slayton, they are not checked in. You may proceed.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. There is rent to retain of $1,884.65. Cost of $242.00 for a total of $2,126.65. We'd be asking for a writ to issue after October 6th.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days.
Here's a reminder of one of the most important realities in eviction court. Showing up matters. When defendants fail to appear, the court generally hears only one side of the story. That doesn't automatically mean the landlord wins every argument, but it does remove opportunities for tenants to dispute balances, explain hardships, negotiate payment plans, or request additional time. Judge Simpson still reviews the numbers and legal requirements before entering judgment, but without the tenants present, there is very little factual dispute left for the court to resolve. Compare this with the earlier case where the tenant actively explained her circumstances. Even though she ultimately lost the motion, she was at least able to present her position directly to the judge. Court participation can significantly affect outcomes. Missing a hearing often limits options that might otherwise have remained available. It's a powerful reminder that ignoring court notices rarely makes legal problems disappear. It usually makes them much more difficult to solve.
Northfield Crossing versus Jessica Bradshaw.
I am here.
Okay, hello, Ms. Bradshaw. Okay, what is the claim now in this case?
Oh, it's been ongoing, let's say that.
Okay,
Your
So-
Honor.
Oh, go ahead.
yes.
Your Honor, I have rent to retain of $1,012.77. Court cost of $190 for a total of $1,202.77.
Okay. And so you made
I've made
your $350 payment.
I actually paid $400 instead of $350. I did do that. I did get a denial from the SER, and I got a phone call from them stating they needed a updated court ledger, which obviously they couldn't give. I called the courts, they couldn't give an updated one because the amount when it was processed was at that time only for the 900. but because when I put in for the SER, because it was for the full amount, because there was 2 months worth of rent. So
Right.
they denied it. They said to get something from Northville Crossings stating how much the full amount was, to reapply, send in all the proof from Northville Crossings with that updated amount with, so I did all of that. I got a phone call yesterday from them. They denied it again.
Jeez.
Yes, and they said because one, I make too much money, and two, the amount was what they say. Your shortfall amount is equal to or greater than the amount needed to resolve the emergency in this emergency. That's why they denied it. But I do have an appointment with Hawk on October 6th at 12 p.m. with Autumn from SOS.
Okay.
Your Honor,
Go ahead.
Yes.
at this point, we would be requesting entry of a judgment. At this time, that is the third hearing now.
No, I understand. Ma'am,
Yes.
if you had just this amount and had to pay it off, how long would that take you to do?
I get paid on the 3rd. I don't know honestly how much it's gonna be. Like I told you, not last time because I was in surgery, which I will be in surgery on the 3rd again with the other doctor that I work with. I've been working as many hours as I can, filling in at another office as well, to make up hours so I can try to get this paid off. So hopefully I get as much money as I can on the 3rd. I honestly, I don't know how much my paycheck's gonna be. Like I
All right.
said before,
I
I
gotcha.
didn't plan on having surgery to have my gallbladder out. That's what sent me behind.
Understood. So here's what I'm going to do, and I'll explain why I'm going to do it. I'm going to issue a judgment to the plaintiff, finding no tribal issue after hearing in this case. All right.
Mm-hmm.
For the total amount of the $1,202. What that does is that, in essence, to save your tenancy, that's the amount that you'd have to pay.
Okay.
If I adjourn it out, we're going to have to deal with October rent.
Right.
Got it?
Mhm.
So, what I will do is, over plaintiff's objection, I'll extend it slightly. Normally, you would have until the 6th to do it. I'm going to, a writ would issue the 10th.
Okay.
And again, that's over plaintiff's objection, but I'm going to give you to the end of that week
To see what Hawk
to
says.
try to see if you can figure it out, get it paid.
Okay. I really appreciate that. Yes, I am trying. I really am.
No, you are. And and you came through and you paid more than what you told me you were going to pay. I get it, but I think this is probably the safest way.
Yes, absolutely. I do. I appreciate it very much so, Judge. Thank you.
Thank you. All right. You have a great weekend.
You too. Thank you.
This is an excellent example of judicial discretion in action. Judge Simpson recognizes that the tenant has consistently appeared, communicated honestly, and even paid more than she previously promised. Those actions build credibility. Notice that he isn't forgiving the debt or changing the landlord's legal rights. Instead, he's slightly extending the redemption period despite the plaintiff's objection. That distinction is incredibly important. The landlord still receives a judgment, but the tenant gets one final opportunity to preserve her tenancy without immediately facing eviction. The judge also explains his reasoning openly, making the decision transparent for everyone in the courtroom. Rather than creating uncertainty with repeated adjournments, he establishes a firm deadline that gives both sides clarity moving forward. This approach balances accountability with compassion, a theme we've already seen several times during today's docket. It's a reminder that consistency and honesty often influence how much flexibility a court is willing to provide.
Scio Farms versus Melanie Clemens.
Mr. Matson for the plaintiff.
Melanie Clemens, they are not present. You may proceed.
Thank you, Your Honor. This case, we were actually waiting for a payment to clear.
Right.
It hasn't come back yet. However, based on the recent charge back for the $3,000 that is being requested. We are requesting another adjournment just to allow for the full period of time for this payment to clear. So
Okay,
to give it the
I do
entire
not-
10 days.
okay. I do not have next week, so I will adjourn it out to October 10th, 2025 at 3 p.m. And has that chargeback been verified? I mean, I know there was some dispute. I don't,
think so, Your Honor. I do have Patty on.
So from
Because-
what we heard,
yes, go ahead, Patty, I'm sorry.
Okay. you're okay. From what my conversation with Melanie was that the owner of the credit card actually did not know what was happening or why there was a fraud alert on it. And he was working on contacting the fraud department to let them know it was an accurate charge. That was as of Wednesday was the last update I had from her.
Okay, all right. Oh, well, we'll see. All right, we'll put it out to the 10th. Thank you.
Thank you, Your Honor.
Court does call the case of Arbor Woods versus Johnson. Are they, oh, there she is. Pardon?
Adrian had to get the kids from
So
school.
you sent him away.
Yes, yes.
All right, no, go ahead. All right, Ms. Mattson.
Good afternoon, Your Honor. Thank you. Casey Matson on behalf of plaintiff. Your Honor, I did have a chance to speak with the defendants. We did come to a proposed consent judgment agreement. The rent to retain is $1,413.68. Court costs of $224.00 for a total of $1,655.68. We did agree that that amount is to be paid on or before October 6th. We had originally agreed to the 3rd, however, upon the court rules, she would get until the 6th to pay that balance, and then
Yes.
October's rent by October 17th. I did speak with them both. I advised them of their rights under MCR 4.201J, and I got their permission to sign. However, Your Honor, since second defendant has left, if we could enter this by hearing or
Yeah, so you can issue I'll issue with all the understanding that they did have their rights, I'll just enter it by hearing.
thank you, Your Honor.
All right. Ma'am, is that all correct?
Yes.
All right. Did you have any questions regarding the terms of the consent judgment? No? All right. Court will enter the judgment for the 165568. Finding no tribal issue after hearing along the terms and paying it by the 6th with October rent being due to 17th.
All right.
All right.
Thank you.
Fantastic. Thank you. You have a great weekend. And tell him to have a good weekend too.
I will.
All right.
Thank you, Your Honor.
Thank you, Ms. Manson. Have a great weekend.
You as well.
Not every courtroom story ends with winners and losers arguing until the final ruling. Sometimes the most successful outcome is a negotiated agreement that both sides can accept. That's exactly what we're seeing here. Before returning to the courtroom, the parties used a breakout room to discuss settlement terms, allowing them to avoid a contested hearing. Judge Simpson carefully confirms that everyone understands their rights before accepting the agreement, which is a critical safeguard in consent judgments. The court wants to ensure that no one is agreeing under confusion or pressure. Once entered, these agreements become enforceable court orders, meaning both landlord and tenant now have clearly defined responsibilities and deadlines. Settlements like this often save everyone time, legal costs, and uncertainty. Instead of gambling on unpredictable litigation, the parties create a roadmap for resolving the dispute while maintaining judicial oversight. That's often one of the most practical outcomes available in housing court.
Calls case of Glencoe Hills versus Yaritza Herrera.
James Singh for the plaintiff.
She's here by Zoom. There she is.
Here. Hello.
Hello. Okay, and where are we now on Ms. Herrera's case?
She owes $965.49. Looks like she still has an app pending. If Miss Amy can confirm that with Miss Herrera's permission.
Miss Amy's not with us today,
Well,
so she has a half payment.
I made a payment today.
yeah, actually, the amount I have is less than the ledger amount, so I think that's right. So her balance now is
580.
Hang on.
965.49. She paid 580 today.
She paid 580.
Yes, sir.
So the number you gave me of the 9, did I take that off of there, or it's already
That's already been, the 580 has been deducted from the 1545.49.
got it? Okay. So Miss Herrera, I know we've been working on this. When are you going to get this paid off?
Stressful. Yes. So I've been working still with the Social Security and
Right.
Section 8. I don't know what to do about Section 8. Nobody in the office is listening to me. I've sent them bank statements that shows that loss of income. I have also went into Social Security and spoke to them in person, where they called my specialist at Section 8 and told them that she did lose that income and they're still not adjusting that. So what?
Who administers your Section 8?
Jacqueline, and then Misty is the supervisor. So I haven't been able.
What company that is, or is it through Mistia?
I don't know what you mean.
Ms. Herrera, is that Misty Hendershot from the Housing Commission?
So it's Ann Arbor. Okay.
And they spoke to Jacqueline, Social Security spoke to Jacqueline on the phone and told her that she did lose that income for her son over the phone, because they're confused of my bank ledgers and what I actually lost. This is going back from May, and they're not adjusting what I should be receiving from them.
Got it.
But I told Social Security that although I have disability restrictions, I need to work. I need to work to get this taken care of because it's going on for too long. And they gave me a ticket to work where I'm still getting Social Security, but I can work and I have a job.
This moment hits differently because the issue is no longer just unpaid rent. Ms. Herrera is describing a survival math problem. Disability income, Section 8 confusion, delayed adjustments, medical restrictions, and now the pressure to work because the system is not moving fast enough. Judge Simpson listens carefully because these details matter. Still, the court cannot force housing agencies or Social Security to instantly correct paperwork. That puts the tenant in a painful position where she may be doing everything right, yet still falling behind. Legally, the landlord is owed rent. Humanly, the tenant is trying to avoid losing housing while navigating bureaucracy. That is the tension housing court lives inside every day. Would you blame the tenant here, or does this sound like a system failure where one delayed adjustment can snowball into eviction risk?
I started working. I'm a dental assistant, so I have that income that's going to be coming in. So next week I'll be getting Social Security. And
okay, Ms. Herrera, let me ask you this. How much is your monthly rent that you
520
Plus utilities.
plus utilities? So we just ballpark it at the 6, because something's gone. And this is the same thing you've been saying all along.
It'll be 1582.47 on the first, adding in utilities and carport.
All right. 1582. All right. So, Ms. Herrera, your October rent with the utilities, so we're talking roughly around $600 or a little bit more. When can you get that paid?
Well, I always make my portion of the payments.
No, I know.
So
I know, but there's a reason why I'm asking it that way, Ms. Herrera.
On the 3rd.
On the 3rd. Okay. And then somehow or another, you got to also whittle away at this 965 until you get everything straight. So how much additional can you pay prior to the 10th to be that next week? Is there anything that you're going to be able to pay?
I cannot say because I'm in clinicals right now and I don't know
Got it.
if they're paying
Okay.
me next week or the following.
Following week. Okay. I got
And
you.
then I do have Hawk. Hawk has approved me, but they don't have the fundings yet until October.
I remember you telling me that also. All right. So here's what I'm going to do. Because I think you're working at everything, trying to get it done, and it's just not happening. So I'm going to adjourn this out to October 10th, 2025 at 12 noon.
Here, Judge Simpson chooses patience instead of immediate judgment, but notice why. Ms. Herrera has made a payment, she has an explanation, she is working with assistance programs, and she appears to be actively trying to stabilize the situation. Courts often respond differently when someone shows effort and documentation, rather than vague promises. This adjournment is not a free pass. It is a short window to keep October rent current and prevent the old balance from growing. That matters because once new rent piles on top of past rent, the case becomes harder to rescue. The judge is essentially saying, keep the current month under control while the assistance and income issues get sorted out. That is practical, not sentimental. It gives the tenant breathing room while protecting the landlord from endless delay. This is courtroom triage. Stop the financial bleeding before the whole tenancy collapses.
You need to make sure
Your
you
Honor?
pay your October. Yes, ma'am.
I was gonna say because I am in the clinicals, I have to be there in the office, and I do not get out until 2 o'clock on Fridays.
On Fridays. Gotcha. All right.
Can we both just appear by Zoom at 3 if we're going to be at?
Yeah, I'll make a. Can we arrange to do it? All right. So here's what we're going to do, Miss Herrera, because I know you're doing everything. I'm going to set yours at 3 p.m., which is a special time. You can appear via Zoom.
Thank you. Thank
and
you.
we'll just see where you are. But make sure you get your October rent in, okay? So
Yes.
that this balance stays about where it is until we can get that other part corrected.
Yes, I'm trying. That's why I was able to make the payment today. I got an increase on my credit card and was able to make the $580. So,
Okay.
and then I've got that ticket to work with Social Security. So, although it's against what my doctors are telling me with my conditions, I have to work at this point because
Okay.
no one is really trying to help me with Section 8, and I need to have that extra income. So thank you for listening to me.
This is one of the most emotionally loaded lines in the entire hearing. Ms. Herrera is not just saying she is short on money. She is saying she feels trapped between agencies, paperwork, medical limitations, and rent deadlines. For viewers, this is where the case becomes bigger than one apartment ledger. Housing assistance programs can be life-saving, but when communication breaks down, tenants may fall behind even while actively seeking help. Judge Simpson cannot solve every agency issue from the bench, but he can recognize effort and structure the case around realistic next steps. That is exactly what he does. He does not dismiss the landlord's claim, but he also does not ignore the tenant's circumstances. Do you think courts should have more power to pause eviction cases when delays come from assistance programs, or would that unfairly burden landlords waiting for payment?
Not a problem, Ms. Herrera. All right. Above all, just make sure to take care of yourself. You hear me?
I'm trying. Thank you.
All right. We'll see you on the 10th, 3 o'clock.
Okay. Thank you, Your Honor.
Thank you.
This docket showed the full range of landlord-tenant court: reversed payments, default judgments, negotiated consent agreements, emergency assistance delays, medical hardships, and tenants trying to buy just enough time to stay housed. Judge Simpson repeatedly balanced two competing realities: On one side, landlords have legal rights when rent is unpaid or judgments remain unsatisfied. On the other side, tenants often arrive with complicated circumstances that do not fit neatly into a ledger. The final lesson is clear: showing up, explaining clearly, making partial payments, and documenting assistance efforts can matter. It may not erase the debt, but it can influence how much flexibility the court is willing to offer. These hearings also show how quickly housing stability can collapse when banking issues, medical emergencies, or agency delays interfere with rent. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.